And now, Legal Perspective with Nick Clekis.
An injury on the job can turn life upside down, but no worker should face that journey alone. Let's welcome back on this week's Legal Perspective, Jackie Drescher, attorney at the Clekis Law Firm. Glad to have you with us.
Good to be here, thank you.
Injuries happen on the job all the time. So what is the first thing that someone should do if they sustain an injury while at work?
Well, obviously you would get the necessary medical care right away. You want to report it to your employer as soon as possible. Sometimes they're aware because it happens on the spot and they see it. But if not, you have 90 days to report it, but the sooner the better. You
have 90 days to report it. So let's say you start feeling that you hurt your neck, but you don't feel it until day 91, it would be too late.
Generally, that is too late. Yeah, you have to report it within 90 days when you knew or should have known about the injury. There are some injuries you may not know about instantly, but you do have 90 days to report the injury. So,
okay.
You want to report it to your employer. Ask for medical care because your employer gets to choose the medical provider in South Carolina. So you need to ask your employer to send you to the doctor and get that medical treatment that you need. The other thing is hopefully consult an attorney to make sure you're getting everything you're entitled to.
And that is the next question that I had for you. Perfect segue, because what are the different benefits that a worker is entitled to?
Well, you are entitled to your medical care by the authorized treating physician. You're also entitled to mileage to and from the doctor, and now actually to and from the pharmacy to get your prescriptions for the related medical care. And in addition, you are entitled to TTD or TPD if the doctor puts you out of work or limits your work. And TTD is temporary total disability. That is the income that you would receive from the insurance company if you're unable to work for more than a week. And the way that works is it's 2/3 of your average weekly wage. They take the prior year, 52 weeks, add up everything you made, divide by 52. That's your average weekly wage. 2/3 of that's your comp rate. And since you're not paying taxes on TTD, it's supposed to be roughly similar to your take home. It's never exact.
Oh, I see. Okay.
But you do have to be out of work more than a week to be eligible.
What if you can't return to your job because of the injury?
Well, while you're treating with the doctor, you're still going to be receiving that TTD if the doctor has you out of work. But if you are released, once you're released from the doctor, if you can't return to the job, they may not be able to accommodate you if you have permanent restrictions. Then that would be something that, I would argue to the adjuster that they're unable to return to the job. You can do an outside source such as vocational rehab. If you need to be retrained in another field. But most people find and segue into either that job or a different job when they're finished with treatment through workers' comp.
What if your employer refuses to file a claim?
Then you definitely need to hire an attorney right away, because I will file the claim. File the Form 50, and I can request a hearing so that the commission can review the case, and you will testify as to your injuries and when it happened. And they may force them to send you for approved medical care.
Okay, so if they're digging their heels in, that's when really having an attorney in your corner is going to help.
Well, it always helps to have an attorney in your corner because it is easier for me to prevent problems than it is to fix problems.
Now, what if your employer decides to fire you because of the claim?
Well, you cannot be fired because you filed a workers' comp claim. If you do, you'd have a wrongful termination claim. And we would recommend someone to help you with that wrongful termination claim. I have learned over the years, though, that if you haven't been employed there very long, the claim would not be as lucrative as if you'd been there for 20 years.
Is there a threshold? A threshold of time?
There is an attorney who works with us on these wrongful termination, and they generally say they want you to have worked there for 2 years for it to be worth their time to pursue a wrongful termination case.
Oh, interesting. Okay, but it absolutely is illegal to be fired because of the injury. But what if they said, well, it's not because of that, it's because they're insubordinate, or they make some other wild claim?
That is interesting, because I've had clients who have been let go and they've said it's for cause, but either you're late to work, not doing your job properly. So one thing I tell my clients is make sure you give them no reason.
And what is the difference between a temporary injury versus a permanent one?
A temporary injury is something that you're going to recover from. A lot of us have a pulled muscle strain or something that you completely recover from. And then there are things like herniated or ruptured disc or other types of injuries that you don't recover from. In workers' comp, if you have a permanent injury, that is where you really look to for the recovery in workers' comp. Temporary injuries, things that heal, there is no money under the law of workers' comp for pain and suffering. So we look more toward what you're permanently going to have to deal with.
Okay, one last question. What if the injury was partially the worker's fault?
Well, if they were within the course and scope of their job, they are covered if they were doing their job. So it's a no-fault system. So, for example, in South Carolina, even if the employer didn't cause the injury, you're still covered.
Okay.
That's in the old days before they had the workers' comp system, you'd have to show that the boss had done something wrong, and that was quite a burden on the employee because sometimes the boss didn't do anything wrong. Sometimes nobody does anything wrong. But even if as long as you're working within the course and scope of employment, you should be covered.
Okay, very good. Well, Jackie, thank you so much for sharing that information with us. And of course, for anybody who wants more information from the Clekis Law Firm, you can always call them direct. I want to thank you again. Great advice.
Thank you.
We'll be back after this.
This has been Legal Perspective with Nick Clekis.